right, good evening, everyone. Welcome to tonight's forum on minority youth, inequities, and justice. This is the third in a series of forums on this topic. My name is Lauren Williams, Adult and Community Services Manager at the Columbia Public Library, which is part of the Daniel Boone Regional Library System. We are glad to be co-hosting this forum tonight. And now I'd like to turn things over to the chair of the Civil Liberties Committee for the League of Women Voters of Columbia Boone County, Pam Springsteel.
Good evening. Welcome this evening. The League of Women Voters of Columbia Boone County welcomes you this evening in celebration of Constitution Day. This is the third in a series entitled Minority Youth, Inequities, and Justice. The previous two are on our website, www.lwvcbc.org, under videos. Tonight, we will examine what happens in the juvenile justice system, what Boone County has done well, and what needs improvement. I wish to thank our many co-sponsors, the Civil Liberties Committee of the League of Women Voters of Columbia Boone County, Alpha Kappa Alpha Sorority Incorporated, Kappa Chi Omega Chapter, Boone County Children's Services Board, Cradle to Career Alliance, Family Access Center of Excellence, which is called FACE, Journey Toward Inclusive Excellence, Mid-Missouri Civil Liberties Association, the Minority Men's Network, Missouri Faith Voices, NAACP of Columbia, the Worley Street Roundtable. Our moderator this evening is DeAndre Thompson. He is the Program Diversity, Equity, and Inclusion Specialist for Boone County Community Services. DeAndre.
Thank you, Pam. Appreciate it. Good evening, everyone. As Pam stated, I'll be the moderator for today's conversation, or this evening's conversation. Before we get started with introducing our panelists, I want to go ahead and give us kind of a synopsis of the previous forums. Again, this is part 3 of a 3-part series. We had 2 prior conversations, and I wanted to go ahead and definitely highlight what took place in those previous conversations. So in part 1 of the forum on inequities and justice, we framed the issue in mid-Missouri during the school to prison pipeline. This pipeline refers to a path from the education system to the juvenile or adult criminal justice system that disproportionately affects students of color. Over the past 2 decades, this path has grown significantly, with the approach to discipline in U.S. public schools having changed with zero tolerance policies in the Safe Schools Act. We learned how school discipline in the criminal justice system or the juvenile justice system are related, and what the inequities are in the system, particularly around race and how they affect young lives in the community. Black students in Missouri, particularly in public schools, are 5 times more likely than their white peers to receive an out-of-school suspension than other students or white students, according to a 2018 report by the ACLU of Missouri. Another report by the Sentencing Project in 2015 found that Black youth in Missouri were 5 times more likely to be detained or committed than white youth. So in the first forum, we heard information from Renita Norwood, who was the supervisor of student services at Columbia Public Schools, around the training they have started to provide staff around implicit bias, focusing on restorative justice practices and separating the deed or the behavior from the doer, and working to reintegrate youth into the school and wider community. We also had Sarah Johnson, a juvenile court public defender, and Ruth McCluskey, who is also joining us again tonight, the chief juvenile officer for the 13th District Court. And we learned about the 2018 Juvenile Justice Reform Act, which requires states to identify and reduce racial and ethnic disparities. We also had Asia Smith, a student at Battle High School, who shared on her experiences with anxiety and relationships between minority students and school staff and school resource officers and the police in general. In part 2, the discussion revolved around ideas or solutions that were very complex in nature and that collectively looked at how individuals from these minority backgrounds dealt with the criminal justice system or the juvenile justice system and how they were disproportionately impacted, and how we have organizations that are taking on the mantle and the responsibility to try to get resources and information available to these individuals and ensuring that they are able to reintegrate again back into society. So we had several panelists join the conversation in order to highlight some of the organizations throughout the community that was doing the work. We had Joanne Nelson, Director of the Boone County Community Services Department. We also had myself, who assisted her in giving information about what the Boone County Community Service Department and our Boone County Children's Services Board supplies in terms of resource for addressing these issues in the community. We also had Core Columbia, an organization that holistically serves male students. And we have 4 students that attended and gave their perspective on what they see in their schools and in our community. And then finally, we had Vernon LeBoy, who is a board member of FACE, the Family Access Center for Excellence, and founder of the Worley Street Roundtable. And so again, as was previously stated, we'll go ahead and speak on today's topic, which surrounds the information, excuse me, that has to do with the juvenile justice system, what Boone County is doing correct today, and how we can take this information and go further in our dialogue. So again, as I stated before I start, I'll go ahead and introduce our panelists. So introducing our first panelist, who is the superintendent, excuse me, of Robert L. Perry Juvenile Justice Center, Tara Eppy. Next, we have Chief Juvenile Officer for the 13th District Court, Ruth McCluskey. Next, we have 13th District Court Family Court Commissioner, Sarah Miller. And then lastly, we have Defense Attorney in 45th District of Missouri, State Representative David Tyson Smith. So again, I'd like to thank our panelists for joining us. And so what we'll do is we'll go ahead and get started with our first question. And then from that, we'll go ahead and open the dialogue up to questions and at the end of this conversation to our audience. So you can submit your questions in the chat and we'll be sure to answer those appropriately. So to initiate our first question, I'll go ahead and open it up to the floor for our panelists. The first question asks, what kind of offenses draw a youth into the juvenile justice system, or offenses? What ages are we talking about? And when does trial occur? So I'll open that up to our panelists. Any of our panelists can go ahead and start with that question.
I'm happy to start with that one. My office, which is located in the courthouse, we receive the referrals on juveniles, so I probably have the most up-to-date information. It's important to know that in Missouri, juvenile court has jurisdiction over child abuse and neglect cases, as well as delinquency and status offense cases. I know for the purposes of this forum, we're mostly talking about delinquency and status offense type cases, but we also have jurisdiction over child abuse and neglect. So we do get referrals on youth for child abuse and neglect concerns. As far as delinquency and status offense referrals, when we talk about status offenses, those are things that are illegal for children, right? So being truant from school, being a runaway, being beyond the control of a parent or other custodian, or engaging in behaviors that are injurious to yourself or to others. So that's pretty broad in terms of what jurisdiction we have for status offenses. And then, of course, we have the delinquency offenses. Those are kids who are under the age of 18 who are alleged to have committed an offense that would be a crime if they were an adult. So things like stealing, property damage. I think it's important to know that kids commit the same offenses that adults commit. It can be something as minor as a trespassing referral that they get referred to juvenile court for, all the way up to a serious felony crime against persons such as a homicide or a robbery or a rape. So we have the large gamut of offenses that we have jurisdiction over. And as far as age range, typically we don't see referrals for kids for law violations prior to adolescent age. We don't charge kids in juvenile court with any type of a crime if they're under the age of 12. Now, we may have some referrals on kids who are younger. A lot of those kids have impulse control issues, might have a history of trauma, mental health problems. So they're having, disruptive behavior at school, being aggressive. So we might be getting referrals on those kids, but those are considered more status offenses, kids who are in need of care and treatment. not necessarily kids who would be charged with an offense. And then, of course, the upper age range is 17 currently. We don't take kids who are 18. They're considered adults currently in Missouri. So I would say for law violation offenses, about 12 to 17, but we do get referrals on kids younger than that, particularly, obviously, kids who are alleged victims of abuse or neglect. So, and I don't know if Karen, you want to add to that, or Commissioner?
Well, I can answer this question about when does a trial occur. The formal court process happens after the juvenile officer has received a referral and then made a decision that there is a sufficient legal basis to file a petition with the court. And when the petition is filed, then a summons is issued by the clerk, and there's actual service of the petition and the summons on the parent, and if the youth's old enough, on the youth, to basically say, come to court, and we're going to appear in front of myself or one of the other judges that hear the juvenile cases. The initial appearance usually involves a brief explanation of the process and notification to the juvenile and the parents that they do have the right to legal counsel. And we discuss that typically to explain that they can hire an attorney, or if they can't afford to hire an attorney, that one would be appointed for the juvenile and or the parents. And then the case, if it's going to proceed, typically counsel would be appointed. And there's usually a process in which the attorneys for the juvenile office and the defense attorney for the juvenile explore the what we call discovery, police reports or referral information, interview witnesses, do some background work on what is behind the charge. And then if we can't reach an agreement, then we set the matter for what we call an adjudication hearing, which is a trial in front of a judicial officer like a commissioner or a judge. And evidence is presented in the form of testimony, witnesses, and the burden of proof is on the juvenile officer to prove their petition, to prove their allegations, and if it's a law violation case, beyond a reasonable doubt. Many of the cases don't have a contested adjudication hearing. The attorneys are able to resolve the issues and reach an agreement, but the youth definitely have the right to have a hearing. They can present their own witnesses and testimony, as can the juvenile officer. And I think most youth would want to have an attorney in that process because it does involve formal presentation of evidence and bringing forward witnesses.
Actually, interesting. Now, I'm curious to hear more, and maybe Tara can speak more from the juvenile office side. Once individuals are, I guess, adjudicated and going through that process, what do those offenses lead up to? Like, are individuals automatically, I guess, sent to the juvenile office, or is there an opportunity for maybe an appeal? I guess in terms of the next steps, what would that next step look like?
And I'm at the detention center. So kids can only be placed at the detention center by court order. So that is through the court process that Commissioner Miller explained. If the court then says, based on these findings, you need to go out to the center for an evaluation period to look into what kind of probation conditions, supervision conditions you need. Do you need a mental health assessment? Do you need a substance abuse assessment? Do you need some educational assessments to go on? Those are all things that we can do after adjudication, but also kind of backing up before that there are certain offenses when juveniles are taken into custody. When they are in custody, there's a decision tool and a process where law enforcement has a youth in custody, for example, for property damage. When law enforcement has a youth in custody, they have to contact a juvenile officer to make a decision about whether that youth can be released back out into the community, whether they need to be on an alternative to detention, like in-home detention, the ankle monitoring devices, or a conditional release, or whether they need to be detained at a secure detention facility pending their appearance before the judge. So we have a scoring tool called the JDTA, Juvenile Detention Assessment, that has been part of the Juvenile Detention Alternatives Initiative, JDAI. I think that may have been mentioned in a previous presentation. But that scoring tool is used in that decision-making on whether a youth comes to detention. So that's kind of before the kids get to court, if they're in custody at the time. So they can come to detention straight from being in custody. They could come after appearing before a judge, and they may need some further assessment before continuing in the community. So they can come to us those different ways. We have 2 different sides of our facility that work on different issues for the youth that are in the facility.
And I'd be happy to address your previous question if you like, regarding the referral process or the different. So referrals can come to us from law enforcement, from a parent, from the school, from children's division. I will say the majority of our delinquency referrals do come from law enforcement, because in order for there to be a criminal charge filed or a law violation filed, there has to be a law enforcement investigation. And the majority of kids who are taken into custody by law enforcement are scored on the assessment tool that Tara mentioned. Law enforcement has to contact the juvenile officer if they have a juvenile in custody, and then we use that assessment to make a determination: should they be released to a parent, should they be placed on some type of alternative to detention, such as like house arrest, or should they be placed in the secure detention facility. And the vast majority of kids who are taken into custody by law enforcement are released to a parent or other custodian at that time. But then there's a follow-up process, because I have an intake unit, and my intake officer then contacts the family, usually by mail, to ask them to come in for an appointment regarding the allegation. And in that process, they have a right to legal counsel. They're informed of that in the letter. Usually the goal is to try to reach what we call an informal adjustment agreement. So these are cases that are being diverted from the court. We're not ever filing a petition. Most kids never see the judge, or about half the kids, I should say, that we get referred for delinquency offenses don't see the judge. But they come in and meet with an intake officer, and if they're willing to agree to what we call an informal adjustment agreement, we can resolve that at that appointment. And those agreements can only stay open for up to 6 months. Most of the time, the things that we're looking for would be to complete community service work. If they owe restitution on the case, we might ask them to get enrolled in counseling. On the more serious cases, or if the parent is advocating for that, they might be assigned a supervision officer who would meet with them periodically for a 6-month period. This whole process, though, is voluntary. So if at any point they deny that there's juvenile court jurisdiction, or do not want to be involved in the informal agreement, they have a right to that. And then we just have to make a determination if we're going to proceed and file a petition with the court. But I looked at my data yesterday, and about half of the delinquency referrals that I received do not actually go through the court process. They're handled out of court through one of these informal agreements. And also, I should mention, one of the dispositions that we have is simply a warning letter. So younger kids, really minor offenses where there's no clear victim or restitution or anything like that, sometimes it's just a matter of sending a letter to the family that says, we received a referral on your child. We want to make sure you know what can be consequences through the juvenile court if we should receive another referral, but we don't actually take any action other than sending them the letter.
Got it. So the letter is, you said it is or is not required to be sent prior to the actual court process?
So the intake officer receives the referrals of kids who are not in custody, who were not detained because they didn't have a high-level felony offense or anything like that, and were released to a custodian. They review that report, make a determination to send a letter to the family to ask them to come in for a conference regarding the referral.
Okay. Voluntary aspect?
That's voluntary, yeah.
Gotcha.
But again, if the informal process in itself is voluntary, and if they don't agree to it, we just have to then determine if we're going to file a petition or not.
I see.
If I could weigh in though, but
Please.
isn't it true though that because with these cases, they usually start, especially if they're minor offenses, with the informal adjustment process, which is great, unlike a regular criminal case where you get charged out of the box and then you have to deal with that. But it would seem that if they don't agree to it, because I know you mentioned it's voluntary, you guys are pretty much going to file a petition. I mean, because the sense is dealing with clients, it's almost, there's a little bit of a pressure there where it's not like, well, it's voluntary. That's something like, I don't want to deal with it. Isn't it true though, that they say no, then most likely there's going to be a petition filed?
More often than not, but not 100% of the time. I mean, we're always looking into what is in the child's best interest. And if we don't feel like it's really worth making them a ward of the court, or that the issues are that severe, and we feel like just having to come in and meet with someone is hopefully going to resolve the concern, then we don't necessarily go ahead and file a petition.
But they wouldn't know that. But they wouldn't know that though until they say no, right? I mean, they couldn't say, well, if I don't, then what? So it's kind of like what's behind door number 2.
And the process is, if they don't want to enter the agreement with the intake officer, that person then follows up with me and with our legal counsel. Then we make a decision if it's one we want to pursue or not. So the intake officer doesn't necessarily know at that time if we're going to proceed or if we're going to just reject the referral. So
I think I wanted to speak on to one of the questions posed in the chat panel. Somebody had asked whether youth continue their education. And I'm assuming that you're directing that to a youth that's in our detention facility. And so the education program at our detention facility is run through the Columbia Public Schools. So we allow Columbia Public School teachers to come out to our facility, and they provide a full school day from 8 to 3:15. We follow the Columbia Public Schools calendar. We don't only hold 13th Circuit youth in our facility though. We have youth from other jurisdictions that don't have their own detention facility. So we may have youth from Moberly, Sedalia, Hannibal. They all receive schooling from the Columbia Public School teachers. And the teachers communicate with the home schools of those other youth, whether we receive packets or now. One of the positive effects that we've seen from COVID is schools going virtual or online, and that has really opened up the ability for the kids at the detention center to continue their own classes from their own schools and continue to make progress in courses they were already participating in. But otherwise, schools have the ability to send packets of work to the kids there, and the teachers assist them with completing those topics and getting the information back to their home schools. During the summer break, we do also do a summer school program out there. It's more enrichment, but for kids that may be credit deficient, we allow them the ability to work on credit recovery courses if they're in the high school grade levels.
Thank you for answering that question. So I'll kind of transition us to the next question, if you don't mind. So there's, I guess, a new law, and maybe someone can preface this a little bit more and give us more detail, that 17-year-olds are now regarded as, I believe, adults or as youth. They're part of the juvenile justice, the trial process. And so with this new law taking into effect, how does that affect youth that are at that in-between age where they're almost going into the legal age of an adult? How does that affect you all as individuals representing different areas of the juvenile justice system? Is there a particular process that is being impacted by the new, I guess, state law that's being instituted?
I would jump in to say, this has been coming for 2 to 3 years now. We've all been aware and been making plans and preparations for those working with those 17-year-olds added to the juvenile system. I think it's something that everyone agreed that 17-year-olds are still youth and need more services, more assistance. So we've been preparing for that. And at the detention center, some things that we're doing is we're preparing to add older youth, more independent living topics to the programming. And we're also looking to expanding to be able to offer high-set prep coursework for some of those youth due to their age and maybe being further along in the high school system.
And there's another aspect to the 17 law. So you have people that are 17 getting charged as or being dealt with as minors or juveniles, which is a good thing. And it's somewhat too early to tell how that's going to shake out. I think it's good. Less people are going to go through the criminal justice system. As a defense attorney, will probably lose money, but I think that's a good thing because they may be able to be dealt with in informal ways as opposed to, and people get attorneys for that, but probably less is probably on a smaller amount than if you had like a regular criminal charge as an adult. But another new law, that's Senate Bill 53 and 60, states that juveniles have to be kept in juvenile detention centers until they turn 18. So even if someone's certified as an adult, they will stay in a juvenile facility until they're 18, which is a good thing. So then you don't have, 15, 16-year-olds in an adult jail, learning from other adults and whatnot. So I'm excited about that change. That just took effect. So that I think that should make a big difference. And there's still ways. I mean, you can have hearings to get the juvenile over to an adult jail, but even if the court decides they need to be in adult jail, I think every 30 days there has to be a review to see if they belong there.
Gotcha.
And from the
go ahead.
Go ahead.
No, you go ahead.
I would just say with the holding certified youth in juvenile detention facilities, we haven't had one in our facility yet. And so that's a good thing. But we are also having to balance. Normally youth are not in detention for a long period of time. It's not a long-term residential type setting. So a youth could be in detention for 2 to 3 days and be released at their detention hearing. A youth average length of stay for youth is 7 to 10 days in detention. Now they may go from the detention side of our facility to what we call the program or the assessment side. And they may be there around 30 days. And again, it's not long-term placement for youth, but those certified youth that we may be keeping in our facility, they may be in our facility for 2 years. If they're certified as an adult at 16, they could stay in our facility until they turn 18 or until their adult cases are resolved. So we're having to be creative in the programming for youth that would stay with us for that period of time. That is something very new for us.
And from the perspective of community supervision, obviously this will result in somewhat of an increased caseload size for us if we were taking on additional age, but we were allocated additional positions by the state to help cover that. I think another concern or focus is going to be on developing programming, community-based services for kids who are 17, who may not be enrolled in school anymore, as Tara mentioned. Need things like job placement, help with high set, and making sure that the programming that we're able to offer them is going to be beneficial given their age and relative sophistication or maturity compared to younger kids. So those are things we're continuing to work on, but we were given additional positions to help with the additional caseloads.
I see. And then that's where, again, as a specialist with the Boone County Community Services Department, we're definitely working alongside organizations that are attempting to receive funding to address those needs. So there's several organizations from Job Point to several other vocational organizations that are attempting to create the avenue for those youth to be able to be taken care of. So when they do interact with the juvenile justice system, or prior to even getting to that point, they want to have the resources available to ensure that they are most successful. So that's definitely a positive there. So I wanted to ask another question, and it kind of goes back to the original intent, I guess, of this conversation, and asking what has the juvenile justice system done well, or what have the Juvenile Justice Office that you all are a part of done well to ensure that our youth in our county and in our community are either diverted or are not going to be held to the same standard, if you will, as adults that are interacting with the criminal justice system. So I'll open that up to anyone who's wanting to go ahead and start that dialogue.
I will answer another one of the questions. Sorry.
Oh, okay.
I'll take on that one just briefly. I think one of the things that our local court has done well is we have been seen, I think, throughout Missouri as in the forefront as a leader with initiatives like the juvenile detention alternatives, with our programming, with our diversion practices. And I think that's something that maybe the community at large is not totally aware of, because it's done without a lot of fanfare typically. I think we've had some success with not detaining youth at the rate that we used to detain youth. We've seen a lot of success with things like home detention, where the youth, they're at home, maybe they're on electronic monitoring, but they can still stay in their own bed, they can go to school, they're not held in the detention center. And so they have that opportunity to be with their family and work with their attorney and go through the court process without having to be held in a secure detention facility. I think over the years, I've seen that alternatives like home detention can be very effective. And certainly during the past year when we had the pandemic and we were, trying to keep kids out of the, congregate facility of the Juvenile Justice Center as much as possible, I was very impressed with how well kids did both on home detention or simply being released back to their family with maybe court-ordered conditions like a curfew or attending school every day or not associating with certain individuals. And those kids, by and large, were very compliant and they didn't have to be in detention.
Got it.
And if I could add to that, so I've been a juvenile officer for 25 years, so I've witnessed firsthand how our system has improved and the progress we've made during that time period, some of the reforms. Like Commissioner mentioned, for the last 10 years, we've been involved with both juvenile detention alternatives, but also disproportionate minority contact, which has since changed to racial and ethnic disparities. But we've been working, to monitor those issues for 10 years now, have community collaborative meetings regarding those topics. I can tell you, I worked 14 years of my career in our juvenile detention facility, and our average daily population would be about 30 kids at a time. And that was primarily Boone and Callaway kids. And I can tell you that now it's more like 10 to 15 at the most. And most of the kids who are being held there are charged with high level crimes or have been under supervision for a long time and have continued to have offenses or referrals to the juvenile office. I also know that our relative rate index is something that we monitor as part of our racial and ethnic disparities committee. And we look at what are the rate of minority youth, particularly Black youth, referred to the court as opposed to white youth. And we've been able to bring that number down from about 7.8 10 years ago to now 4 point something. I just had a meeting yesterday. That's not anything to be proud of, that youth of, Black youth are 4 times more likely to be referred than their white counterparts, but it's lower than it was 10 years ago. And I can also say when we look at the data, once they enter the system, it's essentially equal. Like we're not seeing huge disparities on which kids are referred to court, which kids are detained, which kids are, handled through a diversion or an alternative. So the biggest issue still is at the referral point, but not so much once they get into the system. And so those are things that I feel like we've been doing well. Tara mentioned the school program that they have at JJC. We've also worked with the Columbia Public Schools for 6 or 7 years to have an alternative program for kids who are under court jurisdiction. It's currently called Yes Academy, but these are kids who might have had safe schools offenses and might not have been able to return to their traditional high school setting. And we now have an alternative environment for them to do credit recovery, get a lot of small class size, a lot of extra support, helping them get credits and getting them hopefully transition back into a traditional school. But there are a lot of things that I feel like we've been doing pretty well as a circuit, and just reforms and improvements that I personally witnessed in my career over the last 25 years.
Right.
Yeah, and I agree with both Commissioner Miller and Ruth on those. I think one of the things that we are doing well for kids in the detention center, and I mainly work with kids while they're in detention. Once they leave detention, I don't follow them, but allowing their community providers in to keep working with them while they're in detention has improved, both through the community provider, say their counselor or their substance abuse worker, allowing them to come in and continue those services so they don't have a lapse in those services while they're in detention. So we've really worked hard to continue to provide those services for the kids while they're with us. So I think that's greatly improved. And it's helped the outcomes where there used to be a lot of anxiety with kids in detention. We've seen that decrease over the years by allowing those service providers to come in and maintain contact with the youth while they're with us.
If I could weigh in, one of the problems I think we have, and I agree with Ruth, it is on the referral side. The fact that, minorities are getting referred at a higher rate. 20 years ago, it wasn't the case where, like, for example, an officer might be driving down the street and see two kids wrestling or fighting on a playground. And as opposed to saying, hey, guys, break it up, especially the minority youth, it's, well, let's refer them to the system or detain them. And I see a lot of that in the schools, right? So 20, 30 years ago, if there's a fight in school, you get sent to the office and you get sent home. Now you get a felony or you get referred to the system. And that's a big problem because there's a lot of discretion among those who are arresting people. And so that is something that really needs to be dealt with, but prior to getting into the system, because you don't want youth to get into the system, if you can avoid it. And so I think as a community, we need to do a good job of educating people about, you don't always have to knee-jerk send someone down and get them into the system. Even if it works out as an informal adjustment, it's not positive. There's this idea that, well, everything's confidential. It's not really confidential, because I've been in criminal court and seen people who are now adults and they're at a sentencing hearing, and the prosecutor will say, Your Honor, this person has an extensive juvenile record. So, and that could actually be worse saying that. And sometimes it's better just to say what the record is. I mean, it could be for stealing an apple, multiple times, or being late for, or missing classes. But by saying that, now you're thinking, well, what is it? So it's not really a confidential system. When prosecutors, when they turn 18, when the youth is no longer a minor, those things can be said in court about him. And then that weighs into sentencing when they're an adult. So that's something we need to get a handle on in this community, is this, referring people to the system for things that are relatively minor. There are some serious offenses, but some things should go the other way. And I hate to say it, but I'll tell clients and parents, why'd you call the police? Sometimes there's a situation where, there's a feud at home and the kid's acting up, or maybe he's run out for a few hours and comes back and they're trying to get a handle on it. I think, maybe 30 years ago, you could have called the police and everything's going to be okay. And the officer shows up and says, hey, and sometimes that still happens. And I'm not knocking our officers, but nowadays, a lot of times you have a situation where the officer shows up and now you've got some type of referral, or there's a problem when they should just go the other way on it. And now you've got a kid in the system. And so I have to tell them, hey, unless you have to call the police, don't do it. One thing about the system, so one of the issues too is once they're in the system, I think we're fortunate here in Boone County because, I can't speak to other counties and things that are all over in the state, or the very, northern parts of the state or the southern parts of the state way out here. But we're fortunate in Boone County because of the people I think we have. one thing I don't say is I say this in honesty, not as flattering, but one thing about Judge Miller, I find that I get the sense she's excited being in her court when youth do well. And if they're, they've done the things they're supposed to do and they can get out of the system or off of supervision, I get the sense she's rooting for them. And I don't get the sense where, she's looking to punish, which I think is the way it's supposed to be set up. That may not be the case in other areas. I know in criminal court, adult court, sometimes there are judges who you get the sense are looking to punish and have no mercy. And no matter what you tell the court, they're just going to send someone down. It doesn't really matter. And sometimes to the point where it's shocking what I've seen in criminal court, where when you think about it, some judges will say, hey, maybe I'll think about this for a while. But I think we're fortunate that because of who we have, I think I get the sense that the youth are being treated fairly by the court. And the court is looking to help and looking to provide services. The downside, though, this is one of the problems that I see as well, is in that system, which is more of a system problem, is the length of time people can stay in the system. So, for example, if you steal a candy bar from Walmart as an adult, maybe you pay a fine and you go on your way. Maybe there's probation and it's over. But if you're a juvenile or a youth and you do something like that, now you're in the system and you have court dates and you have to keep showing up. And a lot of times, so what the court does, and it cuts both ways. So they'll say, okay, well, how is a youth doing in school? What's his attendance record? Which are good things, and you want the child to succeed. The problem is, you may have a kid that's, irrespective of his crime, say he wasn't stealing candy bars or bikes or whatever, he might have a problem with his grades, right? And he's struggling with grades just because that's kind of an issue. Maybe he's, going between D's and F's. And that's just an issue he has, irrespective of the crime. But now you've got a situation where once a kid's in the system, the court will say, well, are your grades slipping? And they may be slipping just because the kid's got problems. Well, then it's harder for him to get out and to get released until those things are taken care of, or if there's absentees from school. And so you could have a lot of kids who may have some of these issues already. And yeah, they need to be improved. But when you're charged with something and you're in the court system now, you have to bring all of that up to get out. And so that can be a problem. And so you can have cases where people are in the system for a long time because of these other issues. And that's a problem. And then you have to have their parents come, and sometimes their parents aren't involved, and there's issues with that. And sometimes the parents need counseling. I think our court does a good job of making sure, hey, maybe the parents need there's an issue there, and they need services. And you might have a parent who's kind of transient and is here and is there. And so that makes it difficult for the youth then to get out. Whereas if they were an adult, they could pay a fine or get some SIS or even a deferred prosecution and go their own way. But because there's all these other issues now that courts are looking at, it's designed to help them. It's not designed to be punitive, but now they've got to meet all these requirements to get out, and they can stay in there for a long time.
Right. I think
And you make some excellent points. I would just reiterate, we wouldn't take a kid to court over stealing a candy bar, right? That's a warning letter. That's an informal, if anything. But
Right.
If a kid steals a car, then yeah,
If a kid steals a bike.
Yeah.
Right.
And
Well, and one thing I think over the years, I've come to realize that we don't want to bring youth into the juvenile justice system because they need services.
right.
That's the wrong door. Okay. That's using the wrong system. And I think some of the things that have been done to address that would be, for example, the Family Access Center for Excellence.
I'll bring that up.
And I know law enforcement officers in our area are made aware of that resource and encouraged, for example, if they're called to a home because there is, maybe a dispute, some difficulty with a teenager, they can refer the family to the Family Access Center for Excellence rather than send the referral to the juvenile officer. And I know there's been a lot of conversations about that type of diversion. And there's also between the juvenile officer and Columbia Public Schools, and maybe even some of the other districts, years ago, there was a memorandum of understanding to deal with the referrals such as the school disturbances or fights, and encouraging, and I know Columbia Public Schools has definitely tried to implement more of restorative justice practices. It's hard to turn the big ship when we're dealing with, you know, these big issues. But I think when I look at kids coming in, I want to make sure that we don't bring a youth into our juvenile justice system because they really need counseling only, or maybe substance abuse treatment only. That's not necessarily an appropriate system. I will say that I don't see that, because I think those cases get diverted through the informal process. But keeping an eye, I think, also on what Representative Smith was saying about, we don't want to hold on to kids too long. And when you have reached basically a plateau with a kid, yes, maybe their grades aren't, you know, all A's and B's, but that's a parenting issue, right? That's not a juvenile justice system issue. I can encourage a kid, and certainly I want them to go to school and do their best, but that's the parent's prerogative. That's where the parent and the school and the student need to work together.
Sure.
So I wouldn't want to hold on to a kid just because they maybe need to turn in some quizzes or something.
Right. And I think going back to your reference to the Family Access Center of Excellence, again, that resource is very necessary for those type of instances, because again, we want to be preventative. I see a couple of questions starting to come into the chat about what do you all think as panelists that should be proactive or preventative educational changes to keep you from, you know, even getting to your chambers or getting to your offices. And I think that's where the Family Access Center of Excellence can be that that diversion or conduit area to be able to indicate that. But it also does take the community kind of corralling behind these known resources to be able to ensure that the students get the assistance that they need, but also the families are also supported. Because as Representative Smith said, there may be family concerns that may be premeditating a lot of these actions. And if individuals in terms of the family dynamic aren't supported, that may lead a youth to make an illicit decision to, you know, try to get some help because they don't have the right methods or ways to express how they're really feeling or anything like that. So that's where, you know, we have resources that are available, but it is important that we corral behind those families and the youth themselves to ensure that they are being completely supported and avoiding even the option of being detained or being sent to the juvenile justice offices. And so I guess this kind of leads into our next question, again, from our Civil Liberties Committee. They wanted to know more about what reforms do you all believe would be necessary for our juvenile justice system, kind of a general statement. And if there aren't any specifics that you can provide, what do you all see in terms of the country in comparison to Boone County? Do you all see that would be good for our county in terms of different tactics or different things that would be useful for reforming our juvenile justice system?
Well, I can take a stab at this a little bit from my perspective. I mean, I think we obviously need to continue monitoring and improving issues regarding racial and ethnic disparities, both at the referral point and throughout the system. Mm-hmm. That is always going to have to be a high priority. I think we need to work to develop more effective community-based services for kids, because we don't house as many in detention, which is wonderful, but are they getting the services that are actually going to help them be successful as they transition into adulthood? And how can we provide those? And are those, you know, evidence-based, and who in the community can help us with that, because as they say, it takes a village. And so if there's people who are willing to be mentors or willing to hire some, kids who've been in trouble, willing to, open up community event space to try to help our kids. I think that is a piece that's missing. I agree that Mr. Smith mentioned, Representative Smith talked about, not being confidential. And I would like to have more transparency about the system, and forums like this help with that. Obviously, individual cases, the law does require that those be confidential. And so, if there's a particular case someone in the community is concerned about, we're prohibited from giving out information about that case. But I think certainly these dialogues with community members about how does the system work, and hearing feedback from the community. I know of someone who went through this experience and had a negative experience, so that we can be aware and try to address it. Also, just helping to build public trust and confidence, because if people don't trust the system, they don't trust that those of us who work in the system have their kids' best interest, then it creates barriers in terms of services, follow through, and any effective change for the kids. So anything that we can do that I don't feel like we have historically done very well, engaging with the community and building that trust and confidence. And I appreciate the opportunity to be on this panel, because I think this is a nice first step. So.
And I would just like to add, kind of piggybacking with Ruth on, Boone County has a lot of resources. I mean, we are very fortunate compared to other counties that I hold youth for. Boone County has wonderful resources. I think one of the obstacles that I would like to work on is overcoming the obstacles for the kids and their families to engage in those and get their buy-in. The stigma of asking for help, kind of overcoming some of those things where we have great resources. How do we encourage the kids to buy into being open to receiving that help from someone that has their best interest? The counseling, the job services, the independent living skills, counseling, all of those things. We have that here. We have a lot of those services. How do we help them engage and benefit and move forward by participating in those services that are already available? So that's one thing that I know we're looking at is it a different kind of conversation? Every kid is different and every family is different, and trying to find that connection that works for the kid. So that's one thing that I know I would like to focus on.
Sure.
I think that one issue I don't like is that children can waive the right to counsel. I don't think a youth should have the discretion to say, I don't want an attorney. Now, again, as I mentioned before, we're fortunate here in Boone County, because I don't think, Judge Miller is going to let someone just waive their right to counsel. I mean, obviously they have the option.
Well, and I think we have had a recent statutory change in addition on those issues of waiver of counsel in juvenile court. And I think we're just probably not going to see that happen very often. And I think youth are entitled to counsel. And if their parents can't afford to hire an attorney, we can make sure that they have legal counsel appointed. And we have some attorneys in our community who really are dedicated to representing youth in court, and are willing to take those cases. I think the benefit for the youth and their families is they have someone that they can privately consult with and find out information about what the process is and what to expect and what their rights are and how to best move forward with their case. And those conversations don't happen if the youth waives counsel. And I think with the new law in place, it's basically not going to be a waiver situation. We're going to make sure they have the opportunity to have an attorney. After they talk with an attorney, if they really don't want one, I guess I can't force it. But it's going to be a longer process. They can't just walk in and say, no, I don't want a lawyer.
Right, and that's good. I think, yeah, and I doubt anyone's going to walk out here. Yeah, absolutely. And that's one thing that I'm excited about our county is that I don't see that happening. We don't see the court here allowing that. However, other places, depending on who you're dealing with, you don't know what you're going to get. I also think mental health services, I think there's a gap in the mental health services that some of the youth get as opposed to adults. I'd like to see funding for that and a mechanism for kids to get those services that they need. Also, I wouldn't be opposed to a law that says that youth can't be certified as an adult until they're 14 or 16. There's a couple of bills that are out there that talk about that, as opposed to youth being certified as an adult younger than that.
Got it. All right. So I guess we can kind of roll into some of these audience questions to kind of keep the dialogue going, since we still have a little bit of time here. So one of our audience members asks, what percentage of students needing free or low cost counseling actually receive it? What would our panelists see as the appropriate balance between individual family therapy? And again, I know that with the Family Access Center of Excellence, they do provide some of that therapy services to youth and their families. So that's kind of a segue there. But what do you all see as a need there for our low income or those who are disproportionately impacted receiving those types of services? What do you all see as an appropriate balance for the individual family?
As far as access to those mental health services, as you mentioned, the Family Access Center, I believe that their services are free of charge. They do assessments and then they make referrals to families. Many kids obviously have are eligible for Medicaid. If they don't have it, then they can, I think they have services at the Family Access Center to help them get enrolled, or can refer them to providers who maybe have a sliding scale fee or something like that. So I do think a Family Access Center is the place to start if your child's in need of mental health services and you want to know who takes their insurance provider and whether or not you can afford it. I'm not sure about the question between individual and family counseling. I do think for many of our kids, they're members of a family, and that is one area where juvenile court, you have to address a lot of the issues that are going on. If they have a parent who's not functioning well for whatever reason, that's certainly going to impact them and their behavior, whether it's a substance abuse problem, mental health issue. And the benefit of family therapy would be to address all those things. That's different. One way juvenile court is different from the adult court, right? It's not just about the one offender or the one individual. These kids are minors. They have to rely on their parents for their basic needs, for supervision, for everything. And so I think a family component is always important in juvenile court cases because of those things. I don't know what others would say, though.
I think one area of concern that I've seen with accessing counseling services for the families that we have in juvenile court is it's there, it's just not immediately accessible. And there still are some barriers, at least in terms of how soon they can get an appointment to be seen. And many of the kids or families we see, they've had a crisis event maybe, and they can't wait 3 months for their next appointment to see the provider. And that's where I see we could hopefully get better availability to the families. I know the juvenile officers work hard to try to assist families to get into those services, but when I've had parents come in, they'll sometimes have explained, yes, I've called, but I can't be seen for 30 days, 60 days. And really they need to be able to get in sooner than that. I do know FACE will see them sooner, but actually getting the services, that's the next step. And there's sometimes a delay in that.
And I was really excited to see the information about the 24-hour facility that's going to be opening until it wasn't going to help juveniles. So I think that is a need, and that would help in those crisis situations. That 24-hour facility is for adults. And so I think that could be very beneficial for the juveniles, the youth that we're working with as well.
Now, Representative Smith, I know you work down in Jeff City and work on laws and things like that, and policy. How do you see what you do and what you're advocating for affecting the juvenile justice system in particular as it pertains to those who are disproportionately impacted? Do you see that those that are your colleagues, do you see that there's a need to try to sway them or introduce legislation that will prevent some of our juveniles who are disproportionately impacted from being contacted with the juvenile justice system? Is there any legislation in particular that you're wanting to advocate for?
Yeah, it's an excellent point. I think that it's a matter of education in Jefferson City. People who aren't on, like family committees or whatnot, are not going to be aware of a lot of these issues. And a lot of these issues, unless you're intentional, nothing's going to get done. So you really have to be intentional about it. One thing that's interesting is there was a bill that was moving on the House floor we were voting on, and the law was going to get passed. I think it was a provision about something in regard to determination of parental rights. If someone's, if they're already in custody, or the kids had already been removed, and there was they were delinquent in child support, that could be grounds for potential termination of parental rights. And as we were voting on that, I saw that quickly, and I said, well, I'm going to vote. I don't like that provision, and I voted against it. And several of my colleagues said, why are you voting against this bill? And I said, because I don't like that particular provision. And then someone said, okay, I'll vote against it, and I'll vote against it. And then like 7 other people said, okay, I get it. And someone else was on one of these committees said, yeah, I brought that up a while ago. And so I think it's about education, right? So making sure the members are informed, and you have to advocate for it, because nothing's going to be done unless people are aware of these issues. I mentioned the bills about raising the certification levels. I think that's one way we could deal with some of these issues, at least to keep younger people out of adult prison. But these bills, Senate Bill 53 and 60, that prevent juveniles from being detained in adult facilities, that's a good provision, and that's new. That was a sweeping criminal justice reform bill that's just now coming into place. But I think it's just continual advocacy, right? So in Jeff City, the way the numbers are, I mean, when it comes to issues of crime and minority issues, I'm not trying to play politics here, but usually the Democrats are the ones that are pushing for that. And, as you know, we're in a super minority. So that doesn't mean things can't get done. But what it takes is intentional, active effort. So you have to go to your Republican colleagues and convince them that this is a problem we need to change and help get those bills. You're just not going to do it on your own. The Democrats can't do it on their own. They need to get help with that. So it's doable. You just have to fight.
Sure. So in terms of the actual, going back to the adjudication process, Commissioner Miller, do you see that most young individuals have a concept of, because again, if they're waiving their right to counsel, or if they're wanting to make that decision, do you think they have a good concept of what that process entails? Because I think that, again, going back to minority youth and the disproportionate contact, we see that they're in these situations a lot more frequently. So do you see that they have a concept of what that process all entails, and how do you, as a commissioner or someone who is seen as the judge in that instance, how do you try to ensure that they are properly taken care of or given a fair opportunity?
Well, for most youth, I wouldn't imagine there would be any way they'd have a complete concept of what the juvenile court process entails unless they've been through it before. Mm-hmm. There's just no way they would understand it. I do try to answer questions that the youth or parents might have about the right to counsel, and explain that an attorney would be appointed to them if they can't afford it. the majority of youth, I think at this point, are open to having an attorney, or at least talking to an attorney before they make that decision. I, do recall a case years ago where I had a young man who self-represented through a contested adjudication hearing. He was accused of shoplifting, and we had testimony and witnesses, and he represented himself, and he won his case, and was found not guilty. That doesn't happen very often, and I remember that case because of it. So they do need to have an attorney, at least someone to explain the process. And although I can answer questions, I can't be their advocate. That's not my role, and it would be an improper thing for me to do. But I think most youth now are willing to consider at least talking with an attorney before they make that decision, which I think is a good thing.
Sure. Gotcha. All right. So if there's any other audience questions, again, we definitely want to ensure that we hear from you all as well for our panelists. They provided a lot of insight into the juvenile justice system. Again, there were previous forums that kind of specifically address the school-based side and what individuals in our districts, whether it be CPS or our rural districts, what they're doing to address some of these concerns. But this specific forum is meant to hold those questions regarding the juvenile justice system. So definitely want to preface that. But we would love to hear more from our audience if you all have any other questions. Otherwise, we will wrap it up. But I guess one more question I have, in terms of what we're seeing now with the changes in our demographics in our country and everything like that, and even in Boone County, we're seeing a lot of individuals kind of matriculate through this area. So in terms of how you all see that impacting the juvenile justice system, are there any suggestions or anything like that that you all would highlight in order to ensure that individuals are, like you said, educated or aware, Representative Smith, of what the laws are aware of, different resources that are available to ensure that they aren't disproportionately impacted? Do you all have any suggestions there for those that may be coming, like I said, from different places, whether that be refugees coming from places like Afghanistan or other states due to natural disasters and things like that? What will be your kind of suggestions in that area?
I don't have an easy answer for that one. I think one of the questions that I see from the chat screen might also kind of go with this, which is, what are we doing to address disproportionate minority contact, whether it's racial minority, ethnic minority. So I think that kind of ties into the question of our population becoming more diverse. Well, I think the first thing that we have to do is be aware. And I know that we have had the opportunity through our Juvenile Detention Alternative Initiative, and then now we call it Racial and Ethnic Disparity Committee, to monitor the numbers. And I think overall, one of the things we have to look at is at each point in our process, what are we doing to reduce that disproportionate number of minority youth in our system? And a lot of that is going to need community support. And we can't just do it from the inside out. But I think as we, deal with each child individually, each youth individually, each family, we always have to look at that question. And also look at overall, how are we doing? And, not congratulate ourselves too early on, we've made some improvements, but we're not there yet.
I would
And
say,
Go ahead, Ruth.
I would just mention I've had cases in my career, and perhaps increasingly so recently, where families have come from another country and English isn't their first language, and so we are equipped in terms of the court process of having interpreters. There has to be an interpreter for a court proceeding. We have contracts with Language Line to try to help communicate with these families, but also educating ourselves about cultural differences and reaching out in the community to different agencies. I know, for instance, I've reached out to Catholic Charities before regarding families that we're working with. There's also universities that are here in our region. The University of Missouri might have an expert on a certain culture or a certain language. So I know that we have done that in the past, and we'll hopefully continue to do that as we're working with families, whether it's in the child abuse and neglect arena or in the delinquency side, so that we better understand how they perceive the court system in their country or the government, or how the discipline is, what is acceptable discipline practices in another culture versus our culture, and just making sure that all the staff, all the juvenile office staff are informed and educated about those things and how it affects our practice. I'm sorry, Tara, if you.
I was just going to say that, and I don't know if Ruth covered this during the last presentation she participated in, but we do a lot of data tracking, and we have a lot of that information, historical information on our websites, where you can see the trends and the referral sources, and a lot of that information that we can provide to the public out on our websites. So I would encourage everyone to take a look at that to see it. It lists more details about maybe some individual or specific programs that we do with the youth. And then I was also going to mention there was a question about how many of the students see our roles as punishment. And I had this conversation with the youth in detention just this week, because when kids come to detention, things aren't going well. We don't immediately go into what's going on, and just bombard them. It's okay, we have to take a breather, and we have to abide by detention standards. And one of the things that we do try as much as possible is detention has to be as home-like as possible. And I know that it's detention, it is, but it's not a jail, it's not a prison. And so we do physical recreation, we have school, we have an art teacher, we have a music teacher, we have those things, because yes, did they do something that has required their detention? The judges placed them there, but they are still juveniles, and we have to have that approach with them. We have kids as young as 12 all the way up to the 17-year-olds, and they all have different needs. So kids don't want to be in detention and seeing us, but we also, are trying to skill build with them and role play and build on that while they are in detention with us. So, I hope that answers the question.
Sure.
I have a question. And, I haven't been out to the detention center in a while, but I know that one of the last times I went out, so there's kind of two areas, right? So there's one area that you mentioned that looks very homey. There's desks, and at least when I was out there, maybe beds and whatnot. It looks like it could be a camp or something. But then there's another area, and could you talk about that? Because there's another area that's more there where kids are segregated and they're kind of off from the rest of, which seemed like a much colder area. Which looked more like jail than the other area. Could you talk about why they separate and what that is?
Sure. So most detention centers in Missouri are set up like our detention side, which is that, if you want to call it, the more sterile side of the building. Most detention centers only have that side. They do not have the program side or the post-adjudication side. They only hold pre-adjudication detention kids. So our detention side, there is a female wing and there is a male wing, because we are a co-ed facility. The males and females are separated. They don't interact with each other on the detention side. On the detention side, when those kids are just coming in the building, their court case is pending, their allegations are pending, we provide their clothes. So we provide their they wear sweatshirts and sweatpants. We provide all their hygiene products. They have an assigned room. They have assigned tables to sit at where they eat and have school and all those things. The program side is the post-adjudication, but predisposition, and it is much more homey, if you will. They have the ability on that side to have their families bring in so many changes of clothing. They have the ability for their parents to bring in their own hygiene products and have access to those things. They have a point and level system that they can earn different privileges or the ability to participate, and that's the assessment side. So they've resolved their charges, but the court may want to know more about what's going on before they're released back into the community. So we're seeing, how they're doing in school, interacting with peers, participating in programming, and so that's the program side. Now, one of the things that we're actually in the process of doing because of Raise the Age and holding certified youth and how our population in detention is going to be changing, we've actually worked with our judges and commissioners about blurring the lines between those two sides and grouping the kids more needs-based, what programs they need to participate in. Maybe it's by age or during the school day, maybe it's more by their grade, and not having those two distinct separate sides. But those are kind of the differences. Historically, kids on detention, they're in and it's pre-adjudication. We don't know them well enough to know whether they can have a hoodie with a string in it or shoes with laces. So we provide those things for them. If they stay with us on the program side, we know them. They know the routine, they know the expectations, they know the rules, and they can earn those items to be in the facility while they're there.
So how long could somebody be in that pre-adjudication side? I mean, the more sterile environment.
It depends on their case. They could be in detention 2 to 3 days and released at their detention hearing. They could go to court, their detention hearing. They could stay in detention. They could be at their first appearance. They could ask for a contested hearing. So it depends. Boone County has juvenile court several times a week. So those kids are in court quickly. Their cases move. Other jurisdictions may have juvenile court 1 time a month. And so that kid may be there 2 months before they can get an appearance with their attorney. So it does vary. The average length of stay on detention is 10 to 14 days, but you do have that youth that may be a certification. They may be there 3 or 4 months in detention. And so it really can vary.
Well, I think there was
So
one.
quickly, so they do stay on that more sterile side until the case is resolved then?
Traditionally, so what we're looking at is being able to move them now because the population is changing for us due to those new laws that came into effect. We are looking at creating some different abilities to participate in different activities on the different sides. We have some kids in detention that I would have no problem. Traditionally, it's been their legal status. If their legal status is detention, they are on the detention side. If their legal status is post-adjudication, they went to the post-adjudication side. And so we're looking at now, we have kids that have the ability to be on this side or that side. And so that's what we're looking at phasing into doing with the kids while there.
Thank you.
I know we only have a few more moments left, and I want to make sure to get back to a question I think that may have been missed in the chat. So it was from, I believe, Monica Miller. The question was, what specifically is Boone County doing to have lower percentages of juveniles in the juvenile justice system? So that's the first part of the question. The second part is, what is Boone County doing to overcome systemic racism with our youth of color in the courts? So again, the first question being, what specifically is Boone County doing to lower the percentage of juveniles in the juvenile justice system? And then the second part being, what is Boone County doing to overcome the systemic racism youth of color are enduring while in the courts?
So I can address some of that. So like we talked about, for the last 10 years or so, we've been working on the Juvenile Detention Alternatives Initiative and addressing issues of disproportionate minority contact or racial and ethnic disparities. So we have committees that meet quarterly with community stakeholders, whether it's law enforcement, schools, mental health providers. Those are open meetings. So anyone I would say who's interested in attending, please, email you all and forward that information to us so we can get them included to these strategy sessions, if you will. Some of the things that the Family Access Center, I think that idea came out of this initiative, trying to find a way for schools and parents to make referrals on their kids to try to address mental health concerns without having to make a referral to the court. Because historically, that is what would happen. Maybe a school guidance counselor or principal was concerned about the welfare of a youth and didn't know what else to do except for make a juvenile court referral. And so the Family Access Center is now available to families. So in lieu of a court referral, they can access services for their child without having to become involved in the system. And then as Commissioner Miller mentioned, we've had an MOU in place. I know that it was signed around the time I became the juvenile officer, so about 6 years ago, with Columbia Public Schools and law enforcement to try to address the school to prison pipeline and having low level offenses that happen at school, what they call, low level school offenses not be necessarily referred to the juvenile court. So things like peace disturbance by fighting or misdemeanor stealing, those things, the school administration has discretion to address those, doesn't necessarily make a referral to law enforcement or to the court. And so that has decreased the number of referrals that we get, particularly for school related issues. They try to handle things through restorative practices and so forth, rather than always making a referral to the juvenile office. Now, I will say if there is an incident at school that involves a weapon or there's a serious injury, so the charge would likely be a felony, something like that, we still would be getting those referrals, but that's not what we're talking about, I don't think, not those minor school-based offenses. So I think those initiatives have substantially decreased the referrals that come to juvenile court over the last 10 years. I can tell you when I was a supervision officer about 15 years ago, we would have calls all day long when we were on call, every hour, every 30 minutes from another kid in custody, whether it was a fight at school, drugs at school. I don't see that currently. We still get calls every day, but it's typically more serious type incidents that are being referred to us. So I think that we have made some headway with that initiative in terms of the total number of kids that are being referred, particularly from the school system. I think they've done a lot. I can't speak for Columbia Public Schools, but they've done a lot to educate their administrators and to work on restorative justice practices and to improve consistency about what kind of things are actually referred to the juvenile office. And I guess the second question had to do with addressing systemic racism. I mean, I think that is an ongoing educational process, right? For all juvenile officers, we have required trainings around various issues, including implicit bias. I think it's something that we just will always continually have to work on and be aware of our own cultural biases and how that might impact us professionally and the impact on youth and families and so forth.
Yeah, and I think in terms of the court process also, looking at when we have a youth who has been, because I only deal with kids once they get to court, but when the family and the youth are in court, listening to the parents and listening to the youth if they want to address the court and asking them, what do you think will work for your family? And trying to hear them out. And they may not always agree within the family, but giving them that opportunity to tell us what they see will work for them. And then also examining some of our practices that we've had over the years, things like community service work, for example, which we don't have much of right now because of COVID. But being aware that not all youth have access as easily to get to a community service work event, or they don't have the ability to, call a charity and get in to do some community service work. Some of the things that we traditionally would have kids do, maybe that's not the right fit for that kid. And we need to look at each of those things and make sure that it's something that the family can do, and not have it be part of the court order simply because that's something we've always done.
Sure.
I just quickly, I know we're probably running out of time here. After the George Floyd killing, people talked about, excessive force, how do you stop it? And it's the same answer, I think, even for this. I think it comes down to a heart issue. And in any system, you're dealing with people who make decisions. So you need to have people in power who are wanting to do the right thing and wanting to make the right decisions. There is implicit bias. I know they say that sometimes people view minority youth as older. So if a 15-year-old Black student does something, they almost see them as an adult and treat them that way. So at the end of the day, I think it comes down to the heart, right? Who's in positions of power and who's wanting to do the right thing? Because we can change the laws and add all these programs and throw more money at issues, but the people in power have to be willing to do the right thing.
Well, yeah, that definitely is a great point, and we'll definitely leave it there. So I definitely want to thank you all as our panelists for joining us this evening and providing your insight. It has been a worthwhile time. I feel like the audience definitely has gained something to continue the dialogue and conversation. So as we continue to move forward with these conversations, whether it be through the league or through the Daniel Boone Regional Library or other spaces, we definitely want to ensure that the community has the information they need to address some of these social concerns. So with that, I'll go ahead and turn it back over to Pam to close us out, and Lauren, and we'll go from there.
Thank you, everyone, for attending this evening. I hope that we have learned a lot and that we'll be moved to make some positive changes for these young people in our community. I want to tell you about a couple of things that are coming up with the League of Women Voters. On September 28th is voter registration day. And the League is registering voters outside the Friends Room of the Public Library from 5:30 p.m. to 8. And then on October the 12th at noon is the October Lunch and Learn, and it will be on Zoom. The topic is mental health and substance use. And it's going to be how to start these conversations with your young people, with your own kids. The panelists will be Kim Dude, Laura Powell, and Heather Harlan. And you need to register, and to do that, go to www.dbrl.org/lunch-and-learn. Also, participants will be sent a follow-up evaluation, and we ask that you fill it out and return it. Thank you, everyone, for coming here this evening. I hope you found it as positive as I have.
Thank you for the opportunity.
Absolutely. Thank you. Thank you for inviting me.
Good. Good night, everyone.
Good night.
Goodbye.
Bye.